The U.S. Equal Employment Opportunity Commission has been looking at how employers are treating unemployed job applicants. Two lawyers who testified before the EEOC on opposite sides of the age discrimination question are with us now. James Urban advises Fortune 500 companies on employment law. And R. Scott Oswald is managing principal of the Employment Law Group. Thank you both for coming in.
Good morning.
Happy to be here.
All right, James Urban, let's begin with you because you say this ad issue that we just saw is really not a widespread problem. Explain what you're saying.
Well, Lark, I think if you look on the internet, you'll find examples of such ads that tell people if they're unemployed they shouldn't apply. But I don't believe it's a widespread practice. And the types of companies that I and my firm represent, which are largely Fortune 500 companies, I haven't found any that engage in this sort of overt practice. And there's reasons why they don't, because I think if you are looking to fill a position, you're obviously looking for the most qualified candidate, the best person for the job. And frankly, if you make a bad hire, you're going to be going through the same process 6 or 9 months later.
Scott Oswald, you do see a problem. In fact, you've called it detrimental and discriminatory. What do you see with these ads? Even let's assume that they are mostly online through these various, job sites.
Well, what it does is it has an impact on those that are seeking employment. It discourages people from stepping forward, from applying in the first place. And as Jim has said, most sophisticated employers, they are not putting these kinds of ads online. But what's happening is behind the HR screen, the human resources professionals that pass on these resumes to the hiring professionals. In many instances, they're looking at the period of unemployment, and it's a real stigma. And they're not choosing applicants merely because of the fact that they are unemployed or long-term unemployed.
Well, we recently caught up with the Department of Labor official at a symposium on older workers. Jane Oates, who's an Assistant Secretary of Labor, had this to say about those controversial ads.
We're working on guidance with Justice and EEO right now, trying to go as far as we can to see if, not getting into other protected classes, but how far we can go to tell people that this is wrong.
So clearly what Jane Oates is saying, they're working on guidance, so there could be even more regulation. We certainly have seen states, some have actually passed laws, some are considering it. In your view, James, is this overkill or is this necessary?
At this point,
stand here and make sure that these kinds of practices are considered what they are, which is improper discrimination.
I think at some point you will see published guidance from the EEOC or the DOL or a combination thereof that suggests to employers that if they are screening out the unemployed, considering that as a disqualifying factor, that the EEOC is going to take a long, hard look at that and determine whether there will be a disparate impact upon minority groups, older individuals.
Yeah. Help us explain, help our audience here with that important legal concept of disparate impact, because we do want to get to these new EEOC regulations, but I think we first have to understand disparate impact. So give us the short course on what we need to know about that concept.
Well, it simply is what would otherwise be a neutral factor that has a disparate impact on a certain class. So in this case, maybe older workers. And heretofore, companies that have used these kinds of factors where it hasn't been expressly illegal, it can have an impact on older workers. And that's why making this specifically a protected class under our laws is so very important, because then an employee does not need to rely upon a disparate impact analysis. They can simply say that this is illegal per se and it shouldn't occur.
So help us now with the employer perspective then, with that in mind, on these new regulations from the EEOC that now says, okay, we're going to look at reasonable factors. So that's another phrase that we need to understand in this whole area of age discrimination.
Yeah, I mean, with the new regulations that have come out, they kind of take the employer, I think, one further step than perhaps where they would have to go before if they faced scrutiny of some factor they were applying to their employees. Before, the employer could put forth whatever its practice was and the reason for its practice and argue that it was reasonable. Now you're really having to explain why you have the whatever practice it is in the first place. And the steps really go beyond, I think, what Congress intended.
Your reaction? You
Supreme
like
Court.
the new regs?
I do, and I think it's very important because otherwise these claims simply can't be proved. You must put the employer to the standard to articulate why the requirement is a legitimate business reason up front, because the employee simply is at a disadvantage. It doesn't have the information that's necessary in order for the employee or employees to prove their case.
Where are we in terms of the law? What do you think is going to happen here? Will we see these taken to court? You were mentioning earlier that we've seen a lot of employment cases before the Supreme Court.
Well, yeah, excuse me. The EEOC, right at this point in time, has a big focus on what it terms systemic discrimination, and it is really looking hard at employer practices that the EEOC believes may impact one group or another. An example outside of the unemployment context is employer consideration of criminal histories. The EEOC is being very aggressive in that regard. If you're excluding someone from consideration because they have a past arrest, the EEOC says that's not going to work. You have to show a business reason for that and how it relates to the job. So first and foremost, you have this EEOC emphasis on systemic discrimination. As part and parcel to that, I think it will be looking closely on this issue of are the unemployed being subjected to automatic disqualification.
Well, thank you both for coming in and sharing your expertise. I know you both have been working in this field for a long time and track this very closely. We really do appreciate it.
It's our pleasure.
Thank you, Lark.